Welcome to the Deep Dive. Today we're tackling a really important one, Landlord Tenant Law here in California.
Yeah, it's complex, and things do change. We're zeroing in on what tenants, especially in Orange County, Riverside, San Diego, and Los Angeles, really need to grasp for 2024.
Exactly. It feels like a maze sometimes. So we've looked at some key info, an article from Belong, kind of landlord-focused but useful, and the big tenant's guide from the state.
Right, the SHRA guide. Our goal is pretty simple. Cut through the jargon and give you, the renter, the essential facts so you feel more empowered.
Okay, let's dive in. First off, probably the biggest worry for many renters, rent increases. How much can it go up?
Well, the Tenant Protection Act puts real limits on that. For most rentals, there's a cap.
A cap? How does that work?
It's the lower of two things, either 10% total in a year or 5% plus whatever the local consumer price index increase is.
Ah, the CPI, so it's tied to inflation, sort of.
Exactly. Whichever calculation comes out lower, that's the maximum yearly increase allowed. Provides some stability, you know.
And landlords can't just mention it in passing, right? They need to give formal notice.
Absolutely. Even if you just have an oral agreement, which is less common for long term, but even then, rent increases demand written notice.
How much notice are we talking about?
Depends on the size of the increase. If it's 10% or less, they have to give you at least 30 days written notice beforehand.
Okay, 30 days. And if it's a bigger jump?
If it's more than 10%, then you get at least 60 days written notice.
Good to know. And I heard something about mailing time.
Oh yeah, good point. If they mail the notice instead of handing it to you directly, they need to add another 5 days to that notice period. So 35 or 65 days, basically.
Right. That applies month to month, or if you're in a longer lease?
Applies across the board for rentals covered by the Act.
Okay, let's shift gears to something even more stressful. Evictions. What protections are in place?
California law is pretty strong on protecting tenants from unfair evictions. The big thing is that no-fault evictions are generally banned.
Meaning the landlord needs a legitimate reason, a just cause.
Precisely. They can't just decide they want you out without a valid, legally recognized reason, like not paying rent or violating the lease agreement, things like that.
What about situations like the landlord wanting to move back in or major renovations?
There are specific rules there, too. If they end the tenancy for themselves or family to move in, they generally can't re-rent that unit for at least 12 months. Keeps it honest.
And for remodeling?
They can't just vaguely say remodeling. They have to give you actual details about the work plan, the scope, how long it's expected to take. It can't be just a pretext.
Okay, now there was something in the news about, like, trespassers, SB 602. How does that affect regular tenants?
Right. That's really aimed at squatters and vacant properties.
Yeah.
It helps homeowners remove trespassers faster under specific conditions by extending how long a trespass letter is valid with the police.
So it doesn't change the normal eviction process for someone who's actually renting legally?
Not at all. That legal process, called an unlawful detainer, is totally separate and has strict rules landlords must follow for actual tenants.
And that process is fast, I hear. Summary proceeding.
Very fast. That's the key thing to understand. If you get served with an eviction lawsuit, you usually only have 5 calendar days. 5 days. To file a formal written response with the court.
Wow, that's incredibly tight. No time to waste.
None. You need to act immediately.
What if you think the eviction is wrong? Like maybe they're kicking you out because you asked for repairs.
That's a potential defense. It's called retaliatory eviction, and it's illegal. If you exercise a tenant right, like requesting necessary repairs for habitability, they can't evict you because of that.
Or discrimination.
Absolutely. Evicting someone based on race, religion, family status, disability, any protected characteristic, totally illegal, and a strong defense in court.
Okay, let's talk security deposits. Always a point of contention. Are there limits on how much they can ask for upfront?
Yes, and this changed recently. For leases starting on or after July 1st, 2024, the security deposit can't be more than 1 month's rent for an unfurnished place.
Just 1 month. That's a big change. What about furnished places?
For furnished, the limit is 2 months' rent.
And if you rented before July 2024 and paid more?
Those existing larger deposits are grandfathered in. The new limit only applies when that specific tenant moves out and the unit is re-rented, or for new leases starting July 1st onwards.
Got it. And getting it back, how long do they have after you move out?
21 days. Calendar days. They have 21 days to either return the full deposit or send you an itemized list explaining any deductions.
Itemized lists. And what can they actually deduct for? Not just anything, right?
Definitely not. It's limited to basically 3 things. unpaid rent, cleaning needed to return the unit to the same cleanliness level as when you moved in, minus normal wear and tear, of course.
Right. Wear and tear isn't your fault.
Exactly. And third, repair costs for damages beyond normal wear and tear that were caused by you or your guests.
And they need proof, like receipts.
Yes. They absolutely must provide copies of receipts or invoices showing the actual costs for repairs or cleaning they deducted.
Yeah.
No proof, no deduction, essentially. Transparency is key.
Good. What about that application fee they sometimes charge? Is that part of the deposit?
No, totally separate. That's the screening fee. There's a cap on that, too. It was $62.02 in 2024. It's just to cover their cost of checking credit reports, references, etc.
And if they don't spend it all?
They have to return the unused portion to you.
Okay. Let's talk about that screening process itself. Discrimination is obviously illegal.
Hugely illegal. Landlords cannot discriminate based on race, color, religion, sex, sexual orientation, marital status, national origin, ancestry, whether you have kids, disability, medical condition, age. It's a long, protected list.
And there's something new about credit history, especially for folks with housing vouchers.
Yes, this is important. Landlords can't deny you solely based on your credit history if you receive a government rent subsidy, unless they first give you the option to provide other proof you could pay your share.
Like pay stubs or bank statements.
Exactly. Benefit statements, pay records, bank statements, things like that. And the landlord has to reasonably consider that alternative evidence. They can't just rely only on the credit report in that situation.
That seems much fairer. Okay, what about the condition of the apartment itself? What's the landlord's duty there?
They have a fundamental duty to keep the rental unit habitable, fit for humans to live in.
Which means, what makes a place legally uninhabitable?
It means it has to substantially comply with building and health codes. We're talking serious issues. Lack of effective waterproofing, broken plumbing, unsafe wiring, no hot water, hazardous substances, infestations, unsafe stairs or exits, things that affect your health and safety.
So if your place has serious problems like that, what can you do if the landlord isn't fixing them?
First step is always written notice to the landlord detailing the problem. Give them a reasonable time to fix it.
And if they don't?
Then you might have options, but you need to be careful. One is repair and deduct, where you pay for necessary repairs yourself and deduct the cost from rent. But there are strict limits on cost and how often you can do it.
Okay, what about withholding rent?
That's riskier legally. It's generally only advisable for very severe habitability issues that directly impact health and safety. And you typically should put the rent money aside. It often leads to an eviction case, where you'd have to prove the conditions justified it. Getting legal advice first is really smart for either of these.
Makes sense. What about the lease itself? Oral versus written?
Oral agreements, like month-to-month, are legal for rentals up to 1 year. But leases for more than 1 year must be in writing to be enforceable.
So a 2-year lease has to be written down?
Yes. And even with an oral agreement, the landlord still has to give you a written statement with key info, like their contact details and how rent should be paid.
What if the building gets sold while you're living there?
Your lease generally stays in effect with the new owner. If the property was sold in foreclosure, tenants in possession usually get 60 days written notice to move out.
And your security deposit, does the old landlord just keep it?
No. When the property sells, the selling landlord must either transfer all the security deposits to the new owner or return them to the tenants, minus any lawful deductions. They also have to notify you in writing about what happened with your deposit.
Okay, that covers a lot.
Right.
So wrapping up, what are the absolute key takeaways for tenants in California, especially in our local counties?
I'd say remember, there are caps on rent increases. You have strong protections against unfair evictions. They need a just cause. Your security deposit is protected, with limits on the amount and strict rules for deductions and returns within 21 days. And landlords must keep the property habitable.
Knowing these rights is really the first step.
It really is. Knowledge is power here. Understand your lease, document everything, communicate with your landlord in writing about important issues.
And if you run into problems, especially serious ones like eviction notices or major repair issues,
Don't wait. If you're a tenant in Orange County, Riverside, San Diego, or Los Angeles dealing with eviction, unlawful detainer, or other disputes, getting help is crucial. You can visit martinezlawcenter.com for assistance.
That's martinezlawcenter.com. Definitely a resource to keep in mind.
Yeah. There are also legal aid societies and tenant rights groups listed in that state guide we mentioned too. Lots of resources out there.
So it leaves us with a thought. With all these legal protections available, how can tenants best make sure their voice is heard and their rights are actually respected to ensure they have that fair and safe home?
That's the ongoing challenge, isn't it? Staying informed, being proactive, and knowing where to turn for help when you need it.
Call now 714-442-9741. Thank you.